Good evening, sir. It's our privilege and honor to be here today. Thank you so much for giving us an opportunity and your invaluable time. So, sir, with your permission, can we start our first
Sure.
session?
Good evening.
Thank you so much, sir. So, there are several distinguished legal figures in India, such as Fali Nariman, who initially aspired to join the civil services but later pursued advocacy, and Justice P. N. Bhagwati, who once wished to become a mathematician but ultimately chose the judiciary, have often reflected how their career evolved beyond their early aspiration. Sir, was your entry into this legal field driven by the lifelong passion or the different calling? Furthermore, sir, what has sustained your dedication to this profession throughout your remarkable journey, sir?
In fact, insofar as I am concerned, I have not come in this profession by accident. I have come by planning
Okay, sir.
because I am the third generation lawyer. My grandfather was a lawyer, my father was a lawyer, and then it came very naturally to me that I should join the profession. My elder brother, he chose to go for CA, and he's a chartered accountant. He's working for a multinational in Bombay, and I came into the profession. And so far as sustaining it in the profession, I joined chamber other than that of my father, and I feel fortunate that I joined the chamber where to work was the only passion there. My two seniors, they would all the time would be working on law or they were talking law only. So they had a huge library. I joined the profession in 1989. At that time, there were no computers, there were no digital libraries. So everything was hard, and they had a fantastic library. So we used to spend a lot of time there in the library, working, searching, and then on the next day arguing.
Thank you so much, sir. Sir, our next question. Sir, it has been observed in this profession that junior lawyer often face challenges, for instances, unfair or no stipends, lack of adequate mentorship, etc. Recently, Madras High Court flagged these concerns, ensuring equitable remuneration for them. May we know, sir, if you have ever encountered such issues in your early advocacy years, and if so, and how have you handled these challenges?
In fact, this particular aspect of the matter is very genuine, and it is practically happening across the country, where the juniors are not paid, or either paid then they are not paid adequately, and wherever they are paid, means they are made to work like horses. This is the condition. So far as I am concerned, I also went through the same thing. For 2.5 years, I was not paid any stipend. But at the end of the day, not being paid for 2.5 years is nothing from what, in fact, I learned from that office where I worked. But after that, at the end of 2.5 years, when they started paying, then that was a very handsome payments were being made, and ultimately means what I am today is all because of the work which I did in that office and whatever I could learn from that office. So this is something, but this is true. And how I could sustain, and this is one thing that because of the help which I received from my parents, that they definitely helped me in surviving for all this period. Those were different days. For me, what I required, except for my day to day clothes and food, was only a little bit of money for getting my scooter refilled. I had a scooter at that time, and that also for the purpose of going to the court and to the chamber. But these days, things have changed. The young lawyers, they require a lot of money. Distances have increased, and so many other things are required. There were no mobiles at that point of time. Even for having a good mobile, because that is now a necessity. You require a lot of money even for that purpose. For maintaining those things, you need a lot of money. And therefore, if a young lawyer is not paid anything, he can't survive. Can't survive unless that he has a good family background or the parents are in a position to help them out for that purpose.
Thank you so much, sir, for your valuable experience. So, moving to our next question. Drawing on your experience as a judge in the Rajasthan High Court and later as a Chief Justice in Allahabad High Court, wherein you have seen the two judicial culture. Sir, could you share something about their work style and suggest any practice from one that might benefit the other?
Actually, being a judge of a court and being a Chief Justice of the largest High Court in the country, they are totally two different ball games. As a judge, you are required to follow the dictates of the Chief Justice, and your only intention, if this is I'm talking about myself, is always to give your best, and you are not responsible for the consequences. But as a Chief Justice, besides doing your judicial work, you are also the administrative head of the entire judiciary, the High Court, and the district judiciary also. So that's a totally different ball game. Talking of the cultures of the two high courts, actually there is not much difference between Rajasthan High Court and the Allahabad High Court. The reason which I perceive is because of the fact that our three initial Chief Justices from 1948 onwards, they were all from Allahabad. So they laid down the practices at that point of time, the Rajasthan High Court being a new High Court. So they continued. So I don't find much difference between Rajasthan High Court and Allahabad High Court insofar as working is concerned.
Thank you so much, sir. Sir, our next question. Sir, how do you balance public opinion with a strict adherence to the legal principle? As we have seen in Navtej Singh Johar case, where the court decriminalized the consensual sexual act between the two adults, despite having the mixed public opinions.
The dilemma is always there while you are dealing with a matter where you know that the public opinion tilts towards something else and the legal aspects of a matter or maybe the constitutional jurisprudence tells you to do something else. But once you are dictating something or you are deciding something, you have to give a go by to the public opinion, because a judge can't be seen to be playing to the galleries. He is required to decide what in his perception is legally correct and not what the public perceive to be correct. There are a large number of examples where we'll find that the minority opinions of the past, they have ultimately become the law of the land. So person has to decide based on the legal principles. Of course, public opinion has to be kept in mind, but then it can't guide you in the ultimate decision.
Thank you so much, sir. Sir, our next question. Your Lordship, legal figures such as K. Parasan, the former Attorney General of India, who was prepared to resign when faced with the issue of probable demolition of Ram Setu, exemplifying the tension between the personal belief and law. Sir, in your judicial career, have you ever faced such similar conflict between your personal belief and the law? And if so, could you please share us and how you navigated with that?
Fortunately, that no such issue so far has arisen in my thinking. However, there are circumstances where you feel that in a given case, whether you will be able to do justice, maybe for any reason. And in those circumstances, for a judge, the only option is to recuse from that matter. As soon as he feels or any thought passes his mind that whether I should hear this matter or I should not hear this matter, the only answer should be that I will not hear this matter.
Thank you so much, sir. Sir, the next question. Can you share a case or a situation from your judicial career that was particularly complex or challenging, political or otherwise, and how it influenced your perspective as a judge?
Difficult to pinpoint any one such case, but there was a very interesting situation wherein a candidate who was physically challenged, her candidature was rejected. And when the petition came before the court, the lawyer also was arguing very half-heartedly and said, "Sir, वो issue तो है, but and then the counsel who was appearing on the other side, he naturally was supporting the decision where the candidature was rejected. So I said that I will dictate the order in chambers. And he said that we have to dismiss the petition. But then when I was dictating the order in my chambers, I just felt that let us see what is the requirement of law. And when I looked at the provisions, the provision was that the physical ability was to be examined whether the person can perform the duties. When I look at the testimonials of that student, of that candidate, I found that she has performed very well in the practicals, despite her disability. When she can perform so well in the practicals, then she can definitely perform her duties. So I constituted a medical board only for the purpose to examine whether the candidate can perform the duties which she applied for and was rejected on account of her disability. The medical board examined her and they were so surprised by her efficiency that they took a video recording also of that. That maybe that the court will not believe our report. They took a video recording also of that, and that was presented to us. Means I was a single judge. It was presented to the court, and that resulted in the petition being allowed. And within few days, she was granted appointment because of that. So this is something that at times you may feel as the facts are presented to you that there is nothing in the matter. But if you look at the law, if you look at the other perspective also, you may find something which may favor someone or the relief can be granted. That is more important.
Thank you so much, sir. Sir, our next question. Reflecting on your extensive experience from both the legal practice and judicial arena, so what long-term changes do you foresee as necessary in our courtroom system?
The what is necessary essentially for the purpose of a quick dispensation of justice is one is that we have to fill up our vacancies in time. That is the most important thing which needs to be done. If you have enough number of judges at a given point of time, the disposal takes place. But if they are not there, then naturally it gets reduced to the extent of the vacancies. The another thing is that we need to cut down on the arguing time before the court. Not in all cases, but in certain cases, large number of means arguments, large number of lawyers appear in one matter, 5 lawyers, 7 lawyers, and everybody, even if they are repeating the same argument, that takes a lot of time. Then another difficulty is that the lawyers are not as prepared as they are expected. Because then, if the lawyers are well prepared or they can summarize their submissions, then things can proceed faster. Otherwise, there is difficulty because at times what we see is that they search for the relevant provision, they search for the relevant part of their own pleadings in the court. So that also leads to a lot of wastage of time in the court.
Yes.
So, many legal icons have found ways to unwind from the pressure of the courtroom, like Ramjait Manali used to play badminton to relieve stress. So, may we know what hobbies or activities help you relax and recharge amidst the demands of the legal profession?
Since childhood, I was interested in philately, and I have unique collection. I have all the Indian stamps issued since 1947, and another is that whenever a stamp is issued, a first recovery is also issued. I have a collection where I have autographs of persons connected with this stamp. Like in 1982, a stamp was issued on Mother Teresa when she received the Nobel Prize. So I have autographs of Mother Teresa on that first recover. So that way, I have a large collection of those covers which are very unique. And on my day-to-day unwinding, I love gardening. So even at my own residence in Rajasthan, I have a good garden. And here in the chief's chief's residence. It's a beautiful, beautiful garden that's there. So whenever I get time, I move around there, keep on selecting plants or getting them replanted or replenished, whatever can be done, I do that.
So, moving forward to the next question, in light of the growing number of public protests demanding speedy justice and transparency, do you see these movements challenging the judiciary to not only maintain the integrity of legal process but also to implement measures that strengthen public trust and ensure accountability in its proceedings?
In fact, transparency in any field, that must be the buzzword. There should not be anything for which you say that people are not entitled to know. Everybody is entitled to know about everything, except, of course, that there are limitations on that aspect also. Because in the name of transparency, you can't do away with the oath of secrecy, which is taken at for the judge. There is no oath of secrecy, but on several other fronts, like for the union ministers or the state ministers, they have to take oath of secrecy also. So unless that particular aspect is there, that something needs to not disclosed, there should be a transparency. And insofar as any challenge is required, there is absolutely no challenge because courts are open courts. As to what is happening, what is being argued, is happening before all. Now you have online courts also, and you have live transmission also of what is happening in the court. So there should not be any issue on that. As to the talking of transparency, what is unfortunately happening is that in the name of transparency, people are seeking to put pressure. That we are asking X, Y, or Z question, then you have to answer it. If you don't answer it, you are trying to seek to hide something. That is not a fact in all cases. There are certain aspects of the matter which cannot be discussed publicly. Maybe all those who are connected with that particular aspect of the matter, they can always discuss it, but not that it should be disclosed to everyone.
Thank you, sir. Your Lordship, you have authored a good number of judgments, including the notable ruling in Priyanka Shrimali versus State of Rajasthan, where you stated, a son continues to be a son, both before and after marriage. A daughter continues to be a daughter. This relationship is not affected either in fact or in law upon marriage. Sir, could you please share your general judicial perspective on this ruling, highlighting both its legal foundation and other relevant considerations?
Priyanka Shrimali was a case where there is a provision for grant of compassionate appointment after the death of the government servant. There the provision was that it was available to a unmarried daughter. So in that particular case, which was before the court, a married daughter who was dependent on her parents, because that is also one of the requirements. She moved an application that as my father has died and I have to look after my mother, and therefore I should be given the compassionate appointment. But as the provision indicated that it can be given only to the unmarried daughter, so the validity of that particular provision was challenged, that why it should be confined to unmarried daughter. So in that particular judgment, what there was a full bench of our three judges. Uh, our senior most judge is now judge of the Supreme Court. The next judge, Justice Vishnu, is now the Chief Justice of Guwahati High Court, and I was the third person. So there the basic aspect, the quotation which you indicated is that there is no restriction for the son. That son should be unmarried. The son can be married, but still he can get the compassionate appointment. But if the daughter is married, then she can't get a compassionate appointment. So on that particular aspect of the matter, that this particular quotation that it took place, that we said that a son is a son and daughter is a daughter, irrespective of fact whether she is married or unmarried. But there also we have indicated is that the basic requirement for grant of compassionate appointment, that the son or daughter, whoever claims the compassionate appointment, must be dependent on the parents. Because the earlier view, because larger bench was there on account of conflicting opinions. Earlier view was that once the daughter is married, she goes to the other family and then she has to look after that family. So she is in all cases not dependent. So there was a presumption that she is not dependent. This was a case where she came out with this case that she was dependent. But still, because the provision said unmarried, therefore she was denied that appointment.
So, moving on to our next question. We have read somewhere that the present Chief Justice of Rajasthan High Court, Honorable Justice M.M. Srivastava, has commended you for possessing a rare blend of legal acumen and strong moral principles that reflect your dedication to justice. Sir, how do you sustain this balance between legal expertise and moral strength?
Actually, this is something which comes very naturally. You can't think and do something. And this is what I have been discussing, that morals are something which gives you the baseline for examining anything, what is right or what is wrong. Because if somebody tells you that X thing happened, now you are thinking that whether this can happen or this can't happen, you examine it based on your moral values. Means so many things goes around in the society and you're told that this happened, you get shocked when it goes against your morals. So this is something, and like when you grow up in an environment where your mother, my mother is well educated, she is a MA, way back in 1962 she did her MA and sacrificed everything for bringing up the children. And my father, he was also a postgraduate and did his law. My grandfather. So you grow up in the environment where the things you are told about the rights and the wrongs, and that makes a baseline for you from where you have to examine as to what is correct and what is incorrect. And these are basically what you say is the morals. That's all.
Sir, the Allahabad High Court holds a prestigious legacy where Cornelia Sarabji, the first woman advocate, could begin her practice and inspired generations of women to pursue law. Despite this, Your Lordship, today women take up only around 2% of the representation in this, the largest high court in India. Sir, in your opinion, what may be the reasons for it and what steps can be taken to reduce this gender gap and encourage more women to join the legal profession, especially in the judiciary?
The biggest hurdle or difficulty which I find is that a woman, once she joins the profession, things become difficult for her. And then after marriage, after some time, she is on the family ways. Then insofar as the courts are concerned, the courts don't provide for any such circumstance where in a case if the women lawyers is on the family ways, that is one of the biggest thing, and it is mostly at that point of time that even very good promising young girls who are already in profession, at that stage they have to leave the profession. That is a huge difficulty. So something has to be done, taken care of. Probably one such thing is that they can get into a good partnership as soon as they are in a position to sustain, maybe, because these days people, what, at the age of 23 or 24 they start practicing, maybe 2 3 years into profession they are already working well, so they should get into some kind of group or a partnership wherein this particular point of time in life that can be taken care of. Once they are through that particular stage, then there should not be any problem, and they are then sustaining and growing. This is what, because I've seen, means, for all these years, since almost 35 years into the profession, that good lawyers, we could see them arguing before the court, doing well, and then suddenly they are not to be seen, and then we find that she got married and she is now with the family. She is not doing anything. That has to be, that appears to be the main reason. That appears to be the main reason that they live in between. Because this is a profession where the gestation period is very large.
Yes, sir.
Unless that a person can sustain for 5 years, 7 years, can't start getting returns unless that you join some corporate law firm. If you are into the practice, active practice, there it takes a lot of time.
Continuing with our discussion, sir, our next question to you is, if you could change one thing about the legal profession as it stands today, what would it be and why?
That's a difficult question because for over 35 years now, or like since the time I started understanding, we have been seeing everything happening in a particular manner, and we always found that all is well as to whatever was going on, whatever my grandfather was doing, whatever my father was doing, and whatever I was doing. But one good thing which I think that can be done is like the question which he asked in the beginning about preparing young lawyers
Yes, sir.
and preparing them well, paying them well. I think if that can be done, and if they don't have the difficulty in sustaining at that point of time, I think the quality of profession that can grow leaps and bounds. Because what happens is, it's a very, very practical thing that a young lawyer, 2 years in profession, if he doesn't earn sufficiently, then his family requires him to earn. He also himself requires something to sustain as a young man. And then the biggest casualty is the ethics, where the person would then live away the ethics and get into something which the profession suffers because of that. So that is one thing that can be changed, or it can be provided statutorily. Because in Chartered Accountants Act, anybody who goes for the internship, even he is required to be paid. And not now, since beginning. So that kind of thing, if the Bar Council can provide, because ultimately that is governed by the Bar Council. Bar Council can provide for some such thing. I think that can really improve the quality of the lawyers, of the young lawyers, and that can really help.
So, as we approach the conclusion of this interaction, we would be truly honored to hear your message as the Honorable Chancellor of Dr. Rajendra Prasad National Law University. What would you like to share with its student and legal community?
Insofar as my sharing is concerned, means I can tell you based on my experience of over 35 years is that for succeeding in life, you have to work hard and keep patience. Actually, keeping patience is very important in life.
Yes.
What we have seen over a period of time, that even good, brilliant people, they lose their patience and try to do things beyond the normal course, and which results into some accident happening somewhere. So you have to work hard and keep patience. Success is bound to come. This is what means I can vouch for it, that if you keep patience, because that is very important for even maintaining inter-se relationship. Because if you are two friends, you are two colleagues, even if you are husband wife also, if person doesn't have patience regarding your working or somebody else's working, then there is bound to be a conflict. So there is no substitute to working hard in any case, and this is all.
Thank you, sir, for sharing your invaluable thoughts and taking the time to engage with us in this meaningful conversation. It has truly been honor to learn about your vast experience and perspective and about your thoughts. Your words have not only provided us with knowledge but also the inspiration and motivation as we carry on our own journeys in this profession. We are truly delighted, sir, with this conversation, and once again, we thank you wholeheartedly for your presence and your encouragement.
Thank
It
you
has
so
been a privilege, sir.
thank you so much for giving this opportunity to talk to young people like you.
Thank you, sir.
You are in your first year only, but you have done it so well, so brilliantly. Thank you so much.